Ready, start. Deposition by the injured eyewitness should be relied upon unless there are strong grounds for rejection of his evidence on the basis of major contradictions and discrepancies therein. In the present case before us, it is clear from the record that the defense had not at all challenged the version of PW2, but on the contrary, the defense had admitted his presence at the spot of the said occurrence. Keeping in view the principle that an injured eyewitness enjoys a presumption of truth and the fact that the same is supported by the medical evidence, testimony of PW2 does not suffer from any infirmity and has to be considered while fixing the guilt of the appellants. With respect to the testimonies of PW3 and PW4, who were the eyewitnesses, it has been revealed that they were taking their respective bullock carts loaded with sugar canes towards the northern direction on the Chuck Road in order to get the same weighed. While at the time of the incident, both of them had been in the vicinity of the spot of occurrence and they had accordingly arrived there upon hearing hue and cry and commotion being raised. PW4 had also narrated that he had seen the maid within bracket ridge bracket close which stood demolished and cut off and the middle portion thereof had since been missing from the spot of its existence. While examining these eyewitnesses, the defense had not at all been successful in eliciting any contradiction in their respective evidence, on the basis of which their evidence may be accordingly discarded and thrown out in this matter. Thus, there is nothing palpable or glaring in the evidence of the two eyewitnesses on the basis of which we can be of the view that they are not true or reliable eyewitnesses. Motive, although is a relevant factor in all criminal cases, it however is not a sine qua non for establishing the guilt of the accused persons. Motive, even in a case which rests on an eyewitness account, lends strength to the prosecution's case and fortify the court in its ultimate conclusion. Thus, the fact of motive has to be seen in the light of the other cogent evidence available. The legal position regarding proof of motive as an essential requirement for bringing home the guilt of the accused is fairly well settled by a long line of decisions of this court. These decisions have made a clear distinction between cases where the prosecution relies upon circumstantial evidence on the one hand and those where it relies upon the testimony of eyewitnesses on the other. In the former category of cases, proof of motive is given the importance it deserves, for proof of a motive itself constitutes a link in the chain of circumstances upon which the prosecution may rely. That is because if the court, upon a proper appraisal of the deposition of the eyewitnesses, comes to the conclusion that the version given by them is credible, absence of evidence to prove the motive is rendered inconsequential.